Uh, and happy Thanksgiving. My name is Drew Clark. I am CEO, editor, and publisher of Broadband Breakfast. And I am so happy to welcome you to Broadband Breakfast live online for Wednesday, November 23rd, the day before Thanksgiving. We do these programs, we being Broadband Breakfast. We are a news publication focused on better broadband, better lives. We cover infrastructure. We cover the impact that broadband has. We cover big tech, and we do this every business day of the year. And we also do this event, Broadband Breakfast Live Online, free event available for anyone to come. You can register and watch on Zoom for free. You can also watch on other channels, Twitter, Facebook, LinkedIn, YouTube. And we've been doing it for 2.5 years, every Wednesday. And we hope to continue. We plan to continue. As I kind of alluded to at the moment, we are about broadband infrastructure, but we're also about the use of that infrastructure. And social networks are, maybe it's a little bit old, so to speak, but it is a paradigmatic case of the use of broadband, right? Being able to communicate on Facebook, being able to communicate using these tools is part of what makes broadband impactful for people's lives. And so that's why we care about it, and we cover it, and we report on it. And we have on the page for this event several links to articles that we believe you'll find useful and of interest concerning some of the controversies around big tech. Just another word or two about our kind of programming and time period. We've just come off less than a week ago our annual digital infrastructure investment event. Thank you to those in our audience who, that was an in-person only event. It was at Clyde's of Gallery Place. We took some great videos. There were some great sessions for panel discussions, and you'll be able to watch those as a member of or if you join and become a member of the Broadband Breakfast Club. If you attended, you'll have access to those. We'll be sending more information about those videos out early next week, so stay tuned to your emails from Broadband Breakfast. I also want to highlight some upcoming weeks. We're still tinkering with the program, but we will have programs over the next several weeks dealing with privacy, what to expect with Congress, the role of broadband in multiple dwelling units, and we're going to have a New Year's recap as well as looking forward to the next year on Wednesday, December 28th. So those are just some of the events that are happening soon. But I'm getting ahead of myself. Let's go back to the topic of today, which is Elon and yay and Donald oh my. This has been a exceptionally interesting time for social media. Right. And it's interesting because of what's happening, but it's also interesting because of the policy issues that are behind this, right? With Elon Musk finally taking the reins of Twitter after a 6-month soap opera, will he or won't he acquire it? The last 4 weeks have been just a whirlwind, and you never quite know how much of it is actions for its own sake or actions for news, kind of like another person that we may be familiar with, our former president, Donald Trump, right? And it's where these two intersect that is kind of the core of our discussion today, right? Will Donald Trump tweet or not? His account is now unblocked. It's available. All those historic tweets up to and including the January 6th tweets you can see on Twitter. And so we're going to talk about that. We're going to talk about what the future of social media is like. And I neglected to say, before I introduce our guests, I want to give a shout out to each of our sponsors. We do this free programming every Wednesday because of the support of our sponsors. They include Utopia Fiber, Broadband.money, Google Fiber, Broadband Now, Lightbox, Wireless Infrastructure Association, GeoPartners, Ookla, Michael Baker International, BroadbandToolkit.com, Pinpoint Capital Advisors, Bitstream Communications, Positron Access and the California Emerging Technology Fund. Thank you to our sponsors for enabling this programming. So let's now turn to our 4 panelists, and we're thankful for each of you for making time the day before Thanksgiving. We're going to start off with Mark McCarthy, who's a non-resident senior fellow in governance studies at the Center for Technology Innovation of the Brookings Institution. Thank you for being with us, Mark. Mark's got the red sweater on. Mike, who's next, has the black shirt on. He's the founder and editor of Tech Dirt, coming to us from Silicon Valley. Mike has covered this issue and predecessor issues, and really pleased that you could make time to be with us on this day. Mike, founder and editor of Tech Dirt. Third up will be Randy May, who's the president of the Free State Foundation. I've known Randy for more than 15 years, and we've intersected on a lot of technology, telecom, and policy issues. So great to see you active on this space, Randy. And then finally, batting cleanup will be Brett Swanson, who's a non-resident senior fellow at the American Enterprise Institute. So with Mike Masnick, also in addition to Tech Dirt, runs a think tank called the Copia Institute. I just learned that as part of his bios. So we've got an all think tank panel as I thought about this here. So, all right, without any further ado, let's turn it over to Mark to give your thoughts on this topic for up to 5 minutes. Go for it.
Thanks very much, Drew. I'm going to start with the news of the week, which is Trump is officially allowed back on Twitter. Now, regardless of what you think of that decision, the process of decision making was, how shall I put it, genuinely stupid. I mean, Musk says it was the voice of the people, but Twitter users, they don't make up a political community ruled by the consent of the governed. It's a business. It's run by Musk now, and its users are customers. They're not citizens. This was Musk's decision to make on the basis, hopefully, of a thoughtful assessment of the equities involved, but instead he ran an online poll. I mean, he might as well have asked 10 random strangers on the street and gotten equal legitimacy for his decision. Now, just to be clear, my own take is that public officials and candidates for federal office should be allowed to operate on the major social media platforms. I don't want to compare Trump to FDR, but I'd analogize the situation to the fireside chats in the Depression. I mean, suppose CBS and NBC, the only radio networks in the country in the 1930s, had decided that FDR's fireside chats were really attempts to rally the people to a dangerous form of socialism, and suppose they refused to carry them. Well, that would have been a travesty. And they didn't do it. And in part, they didn't do it because of a regulatory regime that required them to provide public service. Now, we don't have a regulatory regime for social media yet, and probably we don't want to have one like the Florida bill, the Florida social media bill, which provides access for political candidates. But even without a regulatory requirement, I think responsible social media companies should carry political leaders. I mean, Trump is now an officially declared candidate for the presidency. He's informally favored by close to 50% of the electorate. I think it would be a travesty to keep him off Twitter at that point. On a slightly different topic, I don't think the events of the last month are going to lead to a conservative wave on social media. I know Republicans were delighted when Elon Musk took over, but I mean, think about it. Facebook is unchanged. TikTok hasn't swung to the right, and Twitter might not even be around very much longer. Musk is doing such a good job of driving Twitter into the ground, it might not survive. Advertisers, they're pausing their participation, and not just because of safety concerns. Musk has fired or driven away not only the safety staff that are responsible for content moderation, but also much of the sales force that's devoted to the care and feeding of advertisers. It's no longer possible for advertisers even to get accurate metrics on their campaigns. Now, I don't think we can expect Trump to return and reinvigorate Twitter. He has said he's going to stick with his own social media investment in Truth, and he's apparently contractually bound to put his posts there first. But given all the churn, we might see an uptick of conservative postings on Twitter. Now, by the way, there's no indication that Twitter was biased against conservatives before Musk took over. That was largely anecdotal. In fact, the only study I've seen of political pluralism on Twitter, and it was done by Twitter itself back when they had the staff to do that kind of thing, suggested that Twitter's amplification and recommendation engines actually favored conservative tweets over liberal ones. And yet, if liberals decamp to Mastodon and interact even less on Twitter, this might increase the previous conservative bias. But my sense is that that way might lie madness for Twitter rather than a conservative paradise. If Twitter looks like it's going to become the social media platform of choice for the MAGA crowd, but without any real Trump presence, advertisers will almost certainly stay away, which could send the whole system, the whole platform into a downward spiral. Every tech business knows network effects can work in reverse, bringing a company down as well as lifting it up. And that could happen here.
Thank you. Wonderful stage setting. Let's turn now to Mike Masnick. Your thoughts on the recent developments.
Sure. So Mark basically said everything I was going to say, so now I'm just going to wing it in terms of my own comments. It's been really, really interesting to watch all of this play out, and in some ways, it's Musk's control of Twitter has been a replay of what we've seen with Parler, which in theory may be in the process of being purchased by Kanye or Ye or however, whatever he's called right now. And also what Trump has gone through to some extent with Truth Social, in which each of those, Parler, when it launched, claimed that it was going to be, the free speech site. And they had this very weird, completely nonsensical statement on their site when it first launched, saying that they were only going to moderate based on the First Amendment and the FCC. Now, the FCC obviously has no authority over social media, and so it was a very strange and bizarre comment. And of course, what happened was very quickly, people started using the site, and about a week after everybody started pointing out the whole First Amendment and FCC is only how we're going to moderate, suddenly they announced that they had new rules, and they had a list, I think it was 5 new rules, and one of them included no pictures of feces. So, which, whatever your thought is on pictures of feces, they are mostly protected by the First Amendment, and it appeared to be a change in the rules. And the simple fact is that declaring yourself as a free speech site without understanding what free speech actually means is something that doesn't last very long, because in most cases what is happening when you're declaring yourself as a free speech site is you are putting up a signal that says to some of the worst people online and the worst trolls to come and to harass people and to abuse people and to post bigotry and all sorts of other things that will drive off most users. And if you want a site to survive and have revenue, whether it's by advertisers or through subscription models or whatever, that tends not to be the best way to do it unless you believe the vast majority of people who you need on your site and the advertisers who will support it are also similarly trolls and bigots. And so, claiming to be for free speech, and not understanding this is drives you out of business very, very quickly. And that's not even getting into the sort of regulatory aspect of it. The ideas behind, if you do believe in free speech on social media, and I'm sure at some point in this conversation, we'll talk about things like Section 230 and whether or not sites should be required to have certain policies in terms of who they host and who they don't host. The really important thing with Section 230 was that it allowed every website, every bit of private property. Each website is privately owned by whoever owns that website to make their own decisions and to figure out what sort of community they want to have and what sort of community and what sort of speech they want to host. And that is part of the free speech bargain that we get, which is that the First Amendment also has a right of association, and which includes a right not to associate. And that's actually really, really important, because if every website has to be a free-for-all, then you can't have anything that is specialized. You can't have any specialized communities. You can't have any focused communities. You have to allow everybody to talk about everything. In terms of, allowing Trump onto Twitter or not, I think, and I wrote about this, and I'm repeating Mark a little bit, I think that there are really strong arguments in both directions. And I think that there are all sorts of ways that you can argue for that he should be on, as a prominent figure, as a politician. And I think there are all sorts of really strong reasons why he shouldn't be on. And you can argue about, incentivizing violence. You can talk about, pushing disinformation that a website doesn't want to be associated with. These are all valid reasons, but the process in terms of determining whether or not someone should be on is really important. And part of the process is what makes people comfortable with your site. There's a reason why most sites now have something called trust and safety departments, which is part of what Musk has, destroyed at Twitter, because it really is about trust and safety, and it is about getting people to trust your site and trust that the processes behind them are fair and valid. Now, there have always been lots of questions about whether or not the trust and safety policies of the different platforms are fair. Part of the issue is that when you are at that scale, everyone is going to make mistakes. Everyone is going to make decisions that some people disagree with. Everything in those decisions is subjective in some form or another. But again, as Mark noted, all of the evidence, and there are multiple studies. There was the one, Mark cited one from Twitter, but there have been a few academic studies that have all found the same thing, that prior to this, there wasn't any anti-conservative bias in terms of how Twitter managed. And in fact, they seem to bend over backwards to often allow conservatives to break the rules more than others. But there was this perception out there that there was anti-conservative bias, and that something needed to be done about it. So the thing that'll be interesting to me now that you have Trump controlling Truth Social, there was a recent study that also found that Truth Social had the most censorious set of policies, and the most arbitrary, enforced it the most arbitrarily of all of the major websites. And you have Parler with whatever rules it has, and now Twitter, controlled by Elon Musk, doing whatever he wants to do. There are questions about whether or not the push for laws like Texas's law and for Florida's law, it'll be interesting if suddenly these new sites or these sites now run by Elon Musk, how they feel about these laws. And then the one final thing I'll point out is that there are other sort of regulatory and policy concerns related to all of this. One of which was that Twitter, like all of the big social media, this doesn't apply to Parler and Truth Social yet, but Twitter was under a consent decree with the FTC over some privacy violations from 2011. And just earlier this year, they got fined $150 million for violating that consent decree, and the consent decree was updated. And they are still under it. The consent decree runs through 2031. I heard one of Musk's supporters recently go on CNBC and say the consent decree doesn't matter because it was 11 years ago. That's kind of funny when the consent decree is very clearly lasts for 20 years. It's a take. I don't think it will work well in court. Yeah. But they, they're the three people whose heads were basically on the line for violating the consent decree, potentially with criminal liability, all quit on the same day a couple of weeks ago. And I think that was a very telling moment. And I believe that the FTC is paying attention very closely to what is happening at Twitter and whether or not the decisions that the company has been making follow the requirements of the consent decree. And then, of course, finally, we have the EU and the DSA, which is coming into effect, which for reasons I cannot comprehend, earlier this year, Musk met with a EU Commission official and endorsed the DSA, despite the massive limitations it presents for content moderation and free speech questions, and how websites can handle their own private property. I think that it goes against much of what he said and much of how he's acting, and yet he endorsed it, and that will go into effect very soon and may cause a lot of very serious problems for him. And so I think that's something to pay attention to as well.
Well, thank you for bringing in a whole new set of issues. Really appreciate that, Mike. Again, got lots of questions, and we encourage your questions on Zoom and other platforms. Let's turn now to Randy May. Tell us a little bit about what you think about this topic and how it'll come to the fore on a policy end.
Thank you, Drew, and happy Thanksgiving to you, Drew, and my fellow panelists and our audience as well. You mentioned we're all think tankers, Drew. You picked up on that. So just quickly, this anecdote. When I started the Free State Foundation in 2006, leaving law practice to do that, I told my mom at that time, I'm going to start a think tank. And, she was always worried about whether I was going to make a living in whatever I was doing. And she said, "What in the heck is a think tank?" And I said, "Well, I've got to think about that and I'll get back to you." And I never did. So I think, advance the discussion building on what Mark and Mike said, and maybe add some a different perspective. And I just want to tell you basically in sort of a foundational sense where I'm coming from, and I think that'll help us go forward. I have the view, which I've been articulating for a few years now, that in fact there's been too much censorship on Twitter and the other major dominant platforms. In other words, that they're overly or excessively censorious. In articulating that view, I've also been careful to say, from my own perspective, I don't think that means that they should be, Twitter or the others should be, absolute free speech zones and not take down or censor anything. To me, there's a difference between subjects that ought to be topics that ought to be subject to legitimate public debate and other types of posts, say those that encourage terrorism, facilitate sex trafficking, or the like, that most reasonable people could agree could be subject to moderation practices that differentiate them from other topics. I do believe, I'm familiar with the studies that Mark and Mike referred to, the academic studies, which suggest that there's not a bias in the way the sites operate. I believe that on some topics that are consequential topics that matter a lot, that there in fact has been a conservative bias, and so we have a difference there. But I think the Hunter Biden laptop story, and we could maybe talk more about it later, but to me that was consequential censorship action. 6 months later, before a congressional committee, Jack Dorsey said, "Oops, we made a big mistake when we took down the New York Post stories." I could talk about some of the COVID origin post and things having to do with the COVID lockdowns and so forth, where to my mind there was a bias that was a left-leaning bias. And I would make the same points if I thought the bias worked the other ways. But I think I just don't think I agree that that's not there. Now, the question is, if you believe, as I do, that these sites have been too censorious, well, what do you do about it, right? Or what should you do about it? I've been writing a whole series of essays. They're actually on my website, the Free State Foundation website. They're under the rubric "Thinking Clearly About Speaking Freely," and you can find those on the websites. But I'm just going to briefly tell you the points, and then we can discuss them further in terms of where I am at this point. And as someone said, we don't know what Twitter is going to be like tomorrow, much less next week or a year from now. But this is the way that I've come to think about these issues. While I understand the impetus behind calls for regulating social media sites like common carriers, right? That's the Texas law and somewhat like the Florida law. And by the way, the Open Markets Institute just wrote a letter a couple of days ago. Some of you may have seen it. You can find their website. They basically, when you take a look at it, OMI is calling for Twitter to be regulated, in essence, like a common carrier, which was kind of odd. Now, Justice Thomas on the Supreme Court has suggested the same thing, as you know, without deciding the issue. So you get this from the left and the right, the calls for stricter regulation. I'm opposed to that. I've lived in the common carrier world for many decades, and I don't think that. I think they're free market solutions that I want to see be given an opportunity to work before something as drastic as declaring these sites to have to operate as common carriers would be implemented. Because of course, in a common carrier world, Justice Thomas, talks about this in his opinions. Then you don't have the right to exclude anyone. It's basically a non-discrimination obligation. I want to see, and I don't know whether Musk ultimately can do this, and all the chaos that's presently taking place. But here are a couple of things I've suggested. Number one, I think there ought to be, and this goes for Twitter and the other sites as well. I think in their terms of service, they should specify a presumption, a free speech presumption that absent clear and convincing evidence that there's been a violation of some other specific term of service, that they're not going to censor or downgrade or whatever that material. Now, I understand at the end of the day, it's still humans that are making these decisions, in the trust and safety department or whatever. But I think it would change the corporate culture of these social media giants if they actually, or hopefully it might change it if they had talked about a presumption in favor of free speech. Secondly, I think that Twitter, particularly with someone like Musk in control, but it's true of the others as well, they could do a lot more to enable tools that facilitate personalization of the user's experience. I mean, there's some of that takes place now that we could talk about, but I think there's more that could be done to enable the consumers, basically consumer empowerment type of tools that would be useful. These are free market types of things. Finally, I would say 230s has come up, and I think we may talk about Section 230. My own view is that I understand the impetus originally behind adopting it and to give the internet a chance to develop and that, and I think that was fine. I think we're at a point now where there ought to be revisions to Section 230 to essentially narrow or remove the immunity and most recently when I've written about this, I've suggested that the standard ought to be just the same type of reasonableness standard that applies to other businesses in other situations. So those are principal points.
Thank you for that. All right, let's go right into Brett Swanson. The time is yours, and we will then have a robust discussion, I'm sure.
Thanks, Drew, and happy Thanksgiving, everybody. Glad to be here. So I think Musk's purchase of Twitter is a real seminal moment in the history and thus future of free speech. First of all, just operationally, he's focusing on, last couple of weeks on two things, which I think are restoring free speech ethos and operations. And that, by the way, that includes in many cases more content moderation. For example, he said a key goal of his is to get rid of a lot of the bots and spam and other things in a much more effective way, so that the site app is actually much more useful for everybody. So that's more content moderation. And then he's focusing on hardcore engineering, right? He dispensed with lots of the teams that were doing what he thought were sort of superfluous functions. And what's left is hardcore engineers. He may have cut 75% of the workforce, and everybody knew the company was bloated. Stock had been stagnant for over 10 years. Many Silicon Valley companies now are following his lead. Facebook, Stripe, a bunch of others now are using sort of his example to also reduce their workforces, but he's, getting made out to be the big meanie. And in fact, just in the last day or two, we're seeing stories that Musk is hiring engineers back, people that actually want to make the app better and in fundamental ways, rather than deal with the political stuff. And also, I think you could see that with these changes, at least for now, the app's still working. There were lots of predictions that it wouldn't, and you could even see Twitter turn to profitability in short order. On the bigger issues, I think over the last half decade, we've witnessed the most severe collapse of free speech, maybe in American history, both as a concept, as sort of an ethos of what we all support, right? Basically, openness, pluralism. And so it's not just been on social media, but it's been across our institutions, but it's been perhaps most striking on social media, where we've seen it sort of in practice, people getting erased, suspended, and censored. Before this last couple of years, despite many robust disagreements, most Americans agreed on a basic framework of free speech. Not that there aren't details to argue about. I think that has collapsed, and I think, in fact, it's led to profound real-world consequences in the last couple of years. 5 or 7 years ago, if some so-called fringe character were kicked off one of the social media platforms, you might have said, well, it's maybe bad for them individually, but what bigger impact does it have? I think in recent years, we've seen that censorship is, having, like I said, profound social and economic consequences. Randy mentioned the whole COVID episode. So, on half a dozen or more major issues of science, medicine, and public policy, we've seen some of the worst, I think, public policy decisions in a generation or more, leading to catastrophic health outcomes. Now we see, horrible outcomes for the economy, society, and many eminent scientists who were offering a different path, alternative ideas on this most complex issue involving science and medicine and the economy and society, who I think have turned out to be absolutely correct in their prescriptions, were censored. And I think if they had not been, we would have had a much more open, diverse, and ultimately fruitful set of policies that it would have gotten us and really the world through the last couple of years in a much healthier way. And really, this goes, the topic centers on this new concept, supposedly new concept of misinformation, right? And that we need to protect people in the world from misinformation. This is an extremely dangerous path that we're going down. We need to see, who are the most abundant and potent sources of misinformation. And in fact, aren't Twitter and the other open platforms the key correctives, the key error correcting codes to sustain an open society and thus civilization by correcting official sources of misinformation, which are far, far, far more dangerous and entail concentrated systemic risk compared to some, characters out on the internet. So I think this is an absolutely important moment where we have at least one free platform, which I think will create incentives for more openness across the society. But this is just like I said in a recent article, sort of the end of the beginning of the information wars. And we're seeing now in the last couple of days, people advocate that Apple and Google, for example, watch over and, if needed, block Twitter on their app stores, which, as I've said again, once you have one free outlet, the censorship will move to the other gatekeeping outlets. And so that's another sticky policy issue that we're going to have to deal with. But I'll stop there and have a good discussion.
Thank you. Wow. All right. Let me start with a question that isn't strictly political or legal, which is, let's just start with the presumption, which is, of course, patently correct, that as a private platform, Twitter has the ability to choose who it wants to admit and who it doesn't want to admit, and then go on to say, look, it makes sense for these platforms to, try to curb hostile or individuals who are, let's just say, harassing other people, right? Again, not saying they need to, not saying First Amendment requires anything like that, but you can see that type of behavior and why a corporate citizen like Twitter on January 6, 2021 could have such rules in place. And then back to January 6th, you see in real time, an incitement. I think it's pretty clear. President Trump incited this mob. Now, again, whether it'll meet a bunch of legal standards if he were brought to task for it, then you've got people saying, well, look, Twitter already knocks lots and lots of people off the platform for much less behavior. Why is the president of the United States allowed to be on Twitter? So take yourself back to that day and the framework I've just laid out there. And was it appropriate on January 6th for Twitter to take Donald Trump off its platform?
Drew, let me just say something if I could respond first. And I'll say probably yes to your question. So, okay, I've said that and get that out of the way. But I want to make a point about what you said about the First Amendment. You started by saying that these are private entities and they have a First Amendment right to exclude whoever they want to. And I generally, of course, agree with that. I've said the same thing, but I have noted, and I think it's important to understand, and for our audience to understand, that it is possible, depending on whether the Twitter or the other platforms collaborate closely or take direction from the government, for them to lose that First Amendment protection. And often people don't make that distinction or want to recognize that exception to what we call the state action doctrine. And, I don't want to get bogged down right now in all the details, but there have been examples recently, and Mark Zuckerberg has talked about this, I think, and others, when the government has come to them and said, we have this information, it's very important, or you should consider very seriously not, allowing that on your platform. You get very close at that point. Now, it depends on the facts. It depends on, it's okay to share information, but it's possible to lose that First Amendment protection.
Well,
and people say what you said all the time without acknowledging that there can be this collaboration that would remove the First Amendment protection.
All right, Mike's shaking his head. Mike, what do you think?
Yeah, it's a total red herring, right? So there's state action issues are a real concern, and I've called them out for years. I mean, going back decades, I've called out risks and threats of state action. There is no evidence of anything approaching what Randy was talking about right now. In fact, most of the companies spend most of their time, really trying to push back on the government. The thing about Zuckerberg was not that they told him to take down any information. All that was said, and this has been totally taken out of context and twisted around. Same is true of the Hunter Biden laptop story. We could get to that if we want as to why that's an inaccurate description. But what happened was the FBI went around and did information sharing, which is not state action. All they said was be aware that there are foreign influence operations, and that may include leaking information. Be aware. It was not take down anything. It was not do anything. All of these companies have long histories of actually pushing back on government attempts to push them in one direction or another on any of these things. The only thing that has been shown is that, some of the companies have specific portals where the government providers can provide the information, but it's for that reason, so that they are extra careful in terms of whether or not that they can push back on the government and recognize when information is coming from the government rather than individual users reporting stuff.
Mike, didn't Mark Zuckerberg
very quick reaction, Randy. Go quick.
I thought Mark Zuckerberg said that he took what the FBI said to him, not so much in the way that you said it, but as a direction at
no, go listen to exactly what he said. That's how it's been reported. But if you listen to what he said, all he said was the FBI said, be aware that there are going to be foreign influence operations, and that may include leaking information. There was nothing about taking down any information. It was just be aware of what's coming, which is pure information sharing, which I think we agree is not anywhere near crossing the line.
Mark, do you want to chime in?
Yeah, so I think Mike is pretty much right about that particular case, that it's been exaggerated for political purposes to make it seem as though it was state action. But there are instances where the government is collaborating with social media companies, and this has raised concern in many quarters about what's going on there. There's been some degree of transparency about that. The Department of Homeland Security has reports about what they do, and there are internet referral services all over the world that have reports about what they do. But I do think that needs to be given a little bit of sunlight so we can see exactly what the government is complaining about, what they think is a problem, and the advice that they're giving to social media companies. This is not something that should be done in secret and in a way that no one outside of the government and the companies has any idea what's going on. This is part of a general theme that I've got, which is the cure to many ills in this area is not strict government content regulation, it's transparency. Let's see a little bit more about what the companies are up to, and let's see if that gives us a better idea of whether they're being censorious toward the left or toward the right, whether they're going too far in one direction or another. And that, I think, is something that I think left and right could probably agree on and move forward on.
Let me put two more issues on the table here. We got limited time, and we got a crowd that likes to talk. So the two issues I'd like to put on the table are Section 230 changes or not, and we've heard a couple of views already on this. But the second is, it seems almost certain that the Supreme Court is going to weigh in a very substantial way, given the split decision in the overturning the Florida law and upholding but staying the implementation of the Texas law. And so let's have a little bit more about these two laws, what they do, and are they clearly unconstitutional in some people's view, or are they not? And so how is the court's view of the Texas and Florida law going to play into congressional reconsideration of Section 230? Let's let Brett go in first if you want to say something on this.
Yeah, sure. And I'll leave the sort of law to Randy and the others, the lawyers. I'd just say sort of conceptually, I think that Section 230 was a good thing from the outset when we were trying to allow this nascent platform to flourish, and so that it was correct in its goal, its objective. I'd say that it was not particularly well written in some ways and maybe doesn't fit what the internet has become today. And so obviously we want to protect platforms from liability from third-party speakers. That's, I think, sound. But the way that they have, I think, flipped it to use it to become censors and tilt the entire information playing field is unhealthy. Again, I think it's a very difficult, if we want to reform it, which I think we do, I think it's a difficult task to get it exactly right. But I think directionally, we need to preserve the liability protections while at the same time limiting their ability to censor.
Who's next?
I'll jump in because replace in almost all of this discussion, if you replace the phrase social media with news or news organizations, you begin to see how little of this actually makes sense when we talk about getting rid of Section 230, or even the like, if we're talking about transparency, or we're talking about transparency mandates. How would conservatives feel if the government said Fox News needs to be transparent about how they make their editorial decision making? I think everybody would recognize immediately that that is a huge First Amendment concern. Should we talked about transparency on bias? Should there be the government ability to look at how Fox News chooses who it puts on the air and who it doesn't? I think we'd all recognize the concerns with that. So,
but the social media companies say that they're not news outlets sometimes, and other times they do.
What does that matter? Is there some sort of difference in the First Amendment? Does that matter? So
the news outlets don't have the 230 liability protections, do they?
They do for any third-party content. All Section 230 does, this is a huge misunderstanding, all Section 230 does is put the liability on the actual speaker. So when the news organization is the speaker, then fine. Then they have the liability. When it's a third party, when it's not the organization itself that's speaking, put the liability on the actual speaker. All 230 does is directionally doing that. So if you're taking that away, or if you replace it, as Randy suggested, with some sort of like reasonableness standard, then all you're doing is creating a vector for a whole bunch of frivolous lawsuits in terms of having to determine whether or not an editorial decision was reasonable or not.
And so, Mark, you've been patient, and go for it.
So I want to talk about the transparency stuff, which is not the 230 issue at all, and lay out what I think is going on with court review of transparency requirements. Both the Florida bill and the Texas bill had transparency requirements in them, and both courts looked carefully at those measures, and both said we don't want to analogize social media companies to newspapers in this particular area. They're much more like consumer operations. They're much more like people who promise to do certain things. And we can enforce a kind of consumer protection disclosure requirement that can be evaluated under a standard called the Zauderer standard, which says that if it's reasonably related to the state interest in preventing deception, and is not unduly burdensome, these kinds of transparency requirements are perfectly constitutional.
Around advertising. That part gets left out. The Zauderer test is about advertising.
I know, but the court said, I know this was in an advertising, but I think it applies to this context as well. Now, the Supreme Court's going to take this up. Almost certainly, they will reject the content provisions in the state laws, or the non-discrimination requirement in Texas and the access requirement in Florida. But the betting is that they'll uphold the transparency requirements. And this can open up the way for legislatures, maybe even Congress, to step forward with its own transparency rules. And that's what I think is likely to happen when the Supreme Court makes its judgment, perhaps as soon as next June.
Drew, let me
Randy,
just
yeah,
answer.
go ahead, Randy.
Answer your question and follow up on Mark. I think we're all in favor, or I'm in favor of transparency requirements, and I hope they're, if they're upheld, that's fine. But on the content issue, and I've studied the Texas decision, the Fifth Circuit's decision in the law, and let me just make a couple points. Number one, the law, right on the face of the law, it says that these platforms are common carrier like. In other words, so you have Texas declaring in the law, right, that they are common carriers, and that's the effect of what the non-discrimination requirements are. Now, and so the Fifth Circuit said that that's not inconsistent with the First Amendment. When it gets to the Supreme Court, I'm not as clear as Mark is that seems to be that the court will say that the Texas law is unconstitutional. I'm not, as I said earlier, I'm not in favor as a policy matter at this point of imposing common carrier requirements or the Texas. So therefore, I'm not endorsing the Texas law or saying that that's necessarily a good thing. But here's an important point to note about it as a legal matter that a lot of people don't talk about or don't know. If you read the court's decision, what the court is saying is you may not start out as a common carrier, an entity, you may not act like one, you may not be one, but over time, depending on how you act and questions of market power, you may be then compelled by the government to be a common carrier. And that's what, if you look at the Turner case involving cable operators, basically, and look at Justice O'Connor's dissenting opinion, and she was in favor of the. She made the point that you can become a common carrier. The government can compel you to be one, and that's not inconsistent with the First Amendment. And so that could be what happens in this case, although I suspect the court will reject the Texas law. Just one other thing on Section 230.
Okay, quickly,
real quickly. The problem is that and what makes it difficult, the platforms have wanted to have it both ways. They want to be able to say, no, we're open to everyone. We're acting as an open forum. They declare that. But on the other hand, of course, they want to preserve all of their liability, and that's a contradiction that's just exists.
What's the contradiction?
That they
don't private property writers have the right to say we have an open door, but we're going to exclude you if you break our rules?
Not if they're common carriers. That's what I was just saying earlier. They could become.
But if they're not common carriers, is it inconsistent?
If they're not common carriers and they're not compelled to be, then yes, then they would.
Mark.
Even if someone is named a common carrier by the government, that doesn't mean that action is immune from First Amendment review. I mean, you still have to say that it's a substantial interest and so on. And most importantly, the requirement you put on the companies cannot be void for vagueness. I mean, the requirement in the Texas law is not to discriminate based on viewpoint. Viewpoint is undefined. What does that mean? Does it mean you can't get rid of Nazi speech? You can't get rid of hate speech? You can't get rid of racist speech? What does it mean? No one knows. And so here's a requirement of government that no one can interpret. If I were the Supreme Court, I'd declare that void for vagueness in a moment. You can't just wave your hand and say, oh, they're common carriers.
Let's throw another element in here. This is from Michael Shear, a question for everyone. He raises the point about, do you feel that there are market structure problems that stem from vertical integration of content and network access? I think I know what Randy's going to say, so I'd rather hear from other people first. Is there a market structure problem here that might tilt towards calling them common carriers or not calling them common carriers?
I'm going to answer that question. We're going to say something else first, which is this is related to it. On the common carrier question, the common carrier concept is incomprehensible for social media. Common carrier, the point of common carrier, and every common carrier that you look at in the past is about carrying. It's about bringing something, whether it's people or cargo or data, from point A to point B, and then the relationship ends. The difference with social media is you're asking them to host content into perpetuity. And so the idea that you can apply common carrier is beyond all the vagueness and the First Amendment questions. It's not the right concept for something that has to host the content forever, because you raise all sorts of other rules in terms of the market structure and vertical integration and all that kind of stuff. I mean, then you're starting to get into basically competition questions, and those are questions that we handle in other ways. We don't need to handle them through declaring something a common carrier. And what we're seeing is I don't think that the competition question really applies here. We're seeing all sorts of other speech platforms. We saw Parler and Truth Social and Getter and Gab and all of these other ones show up, and now Mastodon, which has been around for a while, is suddenly getting a whole bunch of usage, and we're seeing others launch. There's this Post News has launched, Hive Social is getting attention. There's like 15 other companies that are jumping into the space that,
Right.
if the problem is really that there's not enough competition, we're seeing competition emerge from all of this.
Right. Dissenting views among the three others of you.
No, I think he's right. It's a competition issue, not a social content moderation issue.
Just quickly, and I've already said I'm not in favor of the common carrier regulation, but Mike, over market power, whether a company possesses market power has always been one indicia of whether common carrier regulation should be imposed. There's a couple centuries of cases that go in that way. The other has been whether it's holding itself out indiscriminately. So just traditionally, when you're looking at whether an entity is common carrier, think of these two things, Mike.
Every social media platform has always had rules about what they'll kick people off for, and so that's
the holding, whether or not they hold themselves out.
To it.
And I'm just saying the other one, Mike, is market power. Those are two traditional,
right? And neither apply is what I'm saying. Like, okay. I agree, but neither of them apply here.
Okay.
Well, this has been a wonderful discussion. I'm going to ask one final question, and you can piggyback on that. Anything else you'd like to say as final comments, we'll go in the same order we started in. And so I want to ask a question about the politics of this. And that question is, I know Randy's viewpoints on common carriage from following him in the telecom space so well. And I was wondering, okay, are they going to hold up as we go to the content space? And we are seeing some weird politics, right? I mean, who would have thought that the conservative, the GOP, who for years has criticized the fairness doctrine, is now much closer, in my opinion, to a trajectory of some sort of requirement like that. Now, not saying the Democrats are immune to that too, but let's just take a stock of this political moment and what we're going to see from who wants what with the speech rules going forward, because there will be speech rules, whether determined by the court or by Congress or by corporate norms imposed through market power. So with that, a little bit broad, but still hopefully enough to dig your teeth into question, let's hear from Mark, Mike, Randy, and Brett.
So a great closing question. Look, the conventional wisdom has been that Congress can't act in the social media area because liberals and progressives want action to remove lies and hate speech and misinformation from social media, and the conservatives want equal time for conservative voices. So there's a logjam, gridlock that can't move. I think it might be broken if, as I predict, the Supreme Court says that the only way you can regulate social media companies is through transparency. Then the conservatives have to give up their goal and the liberals have to give up their goal. But what they can agree on is let's have some openness and transparency for social media companies. I don't think it's going to happen until the middle of next year when the court acts. But after that, if there really is a roadblock preventing these other ways of regulating social media companies, I think at that point, Congress will coalesce and move something in the area of transparency.
Great crystal ball there. Mike, what are your thoughts on this?
Yeah, I mean, Mark might be right, but I think that it would be pretty bad no matter what. I think politically, both parties are bad on this issue. I think both have desires that I think run against the First Amendment. I think both of them have shown, in often contradictory ways. And we're seeing, we talked about the Texas and the Florida law around content moderation, but we have laws now in California and in New York coming from the other side of the aisle that I think are equally problematic, some of which are transparency elements and some of which are others around, they're not as blatant, but they are nudging companies to moderate in a certain way. And I think those are equally unconstitutional. I think those deserve to be struck down as well, though I have no idea if anyone will actually challenge them because they're often framed in the framing of protecting the children, and nobody wants to say that they're against protecting the children. So we have, both sides of the aisle are basically really trying to control speech in one way or another on social media, and I think all of that violates the First Amendment. Whether or not the Supreme Court will recognize that, I have my doubts and my fears, but I think both sides are really playing a dangerous game with the First Amendment.
Thank you for bringing that perspective to this discussion, Mike. Randy.
Thank you, Mike, and thanks, Drew. So I'd like to conclude this way. I am a strong advocate for First Amendment principles from the very beginning. At the Free State Foundation, we have proclaimed that as part of our mission in various respects. A lot of respects, we've advocate for the First Amendment, and I've so specifically in our discussion today, I pointed out one possible exception, but I recognize the First Amendment rights of these entities, absent that collaboration that I possibly talked about. That's important. But here's the point that I want to make: the free speech, to my mind, is a really important part of our culture, what I like to call our constitutional culture in this country. There's a reason we have the First Amendment. So even when the First Amendment doesn't require that the social media sites do something, especially when it doesn't require that they do something, I really would like to see them and other institutions, Brett talked about the other institutions as well, which are important. I'd like to see our leaders, and especially the leaders of these companies, be leaders in talking about the value of free speech and operating the sites so they're less censorious. I don't mean absolute. I'm not in favor of everything goes except if lawful speech. I mean that's a model too that could be tried, but that wouldn't be my model. That wouldn't be my model. But here's the point: we need to have a constitutional culture that values free speech, absent of some strict absolutist First Amendment interpretation that requires it. And maybe Musk can help do that. Others should. We all should really, hopefully, be articulators of that constitutional culture. Drew, thanks so much.
Well, awesome. We have one more final word. Brett Swanson, go for it.
Yeah, thanks, Drew. Appreciate it. Randy, I totally agree with that free speech and pluralism as an ethos for the country and really for the West are, in fact, more important than the First Amendment. The First Amendment undergirds that. I think we need a deeper appreciation of that across all of our institutions. But this is why I'm celebrating Musk's purchase of Twitter and his advocacy of these basic values. It'll be messy in practice, but at least he's headed back in the right direction. And this is the type of entrepreneurial, market-based dynamism that I much prefer to all the regulations and court cases and so forth, which I think could act to undermine various parties' First Amendment rights. And so this is the direction I hope we can continue going, but it requires at least some openness at various layers of the internet, which is this abundant place, right? It's theoretically infinite space for speech and apps and so forth. And so that's the ultimate solution, but we've got to have some measure of openness so that we allow these market-based entrepreneurial dynamic solutions to give people voice and to help solve some of these possible market problems.
Well, that will have to be our last word. On behalf of our wonderful guests, Mark McCarthy, Mike Masnick, Randy May, and Brett Swanson, I'm Drew Clark with Broadband Breakfast. See you next Wednesday at 12 noon. Everyone have a wonderful and happy